MTN Ghana has withdrawn its case from the Supreme Court, seeking a review of the High Court's decision declaring it a significant market operator. Joy Business understands lawyers of the telecom market leader informed the court they have been advised to withdraw the case to pave way for stakeholder consultations. The Supreme Court subsequently struck out the case as withdrawn. The lawyer for the National Communications Authority, Gary Nimako Mafo, spoke with Joy Business after Tuesday's hearing.
Well, I think that basically what MTN has done appears to me a very good step. I have maintained from day one that the right procedure would be to engage the regulator, because if you look at the documents so far available, the issue about not being heard, to me, in my view, was not the best approach. You should engage the regulator, talk to the regulator. Best legislative practice requires that they must all sit down, they must all talk, find amicable way of resolving the problem. So I think what they've done, to me, is the best approach that they have, resolved the trigger.
We're joined via Zoom by Apiakusi Adomako of CATS International with more on this development. Thank you very much, Mr. Adomako. Will you call this a retreat by MTN, and what's your understanding of the move?
I don't think it is a retreat by MTN. I think it is the best practice for MTN to have engaged with the regulator. Where you cannot challenge, of course, you have a constitutional right to go to court to challenge any issue that you are not satisfied with. But I think that when you have negotiation between, adjudication in court, I think that you would rather prefer to go for negotiation, which will yield a win-win solution, a win-win outcome for both parties. Because for the court, you are not assured whether you get the judgment to go into your favor. But when you go onto the table, at least at the end of the day, it will be a win-win between the player and the regulator. So I think that MTN going to withdraw the case is a sign that there's understanding, and also they believe that the regulator has exhibited a good faith that when they sit before the table, there can be an optimal solution for this issue.
All right, so it's understandable that MTN has decided, as you're saying, to withdraw this case, probably because they feel that the better approach would be negotiations. But I'm sure they had benefit of this this advice before they actually went to the Supreme Court.
Yes, I think at the beginning, we're also one of the people who suggested that going to court may not be the best option when you have not engaged the regulator to understand their concern and also understand the issue very, very clearly. But of course, it is always better than none. If you make a mistake, it doesn't mean that you continue to escalate the mistake that you have made. So coming to court, going for negotiation, I think it's a sign that MTN believes in the system. And also, as I said, that the regulator has also exhibited a sign of good faith that once they sit down, the outcome will be beneficial to both parties as well as consumers and other players in the telecoms market.
Mr. Adomako, could it also be that they have benefit of some information that suggests that they probably could be losing?
I wouldn't want to say this, that they have a benefit of some information. This issue of significant market player, it borders more of economic principle than legal litigation. And so for me, the court may not be able to do justice to the economics of the issue. But when the two parties sit down, MTN brings their economic experts, NC also brings their experts, and then they look at which of the angle is giving us the best outcome. And then I don't know, at the end of the day, the expert opinion should be the way forward. Because a judge decision is more or less like a binary. When you go to court, it is two outcomes, whether you lose or you win. The court will not come and so 50 for MTN, 50 for NC. But once you go through this negotiation, you see that it is better because at the end of the day, you will still need the regulator. The regulator will still be the one to pretend over the market. So if you go to court and you win or you lose, I mean, it may create a kind of a bloodbath or something else between you and the regulator. And so I think that for going forward, MTN might have weighed all the options based upon the best practices and decided that, of course, if they go for negotiation, they can still come back to court anyway. So that is also another thing that you must also understand.
Do you foresee a situation where the regulator, the NCA in this case, could soften its stance on the fact that MTN is a significant market player?
I think the regulator is to ensure a level playing field for the market. And so it is not about the regulator softening its stance. The regulator is there to ensure that the market functions at optimal level. And this is an issue of fact, not an opinion. So I think that NCA may decide that, look, instead of taking these measures within a short time, let's give ourselves a year or two to implement those reforms so that at the end of the day, MTN will not suffer unduly within the short time. And that could be something that the regulator can do in terms of the implementation of these measures. I mean, I also believe that all the measures should not be deployed immediately after the negotiation. They have to give them some time. MTN has invested, so their shareholders are also expecting a return on their investment. So I think that the regulator would need to be guided by the best practice, so that at the end of the day, everybody will feel and be satisfied after the table, the meeting has ended.
Now, it's obvious that MTN is going to come out of this impacted adversely, but is there a way that it can minimize the adverse impact?
I wouldn't say that MTN would come out impacted. I mean, adversely is too strong a word to use, but I think that.
But clearly, they don't like what this is. They don't like what's going on, and which is why they're fighting it.
Yes, because for MTN also believes that with them by happen and come up or if the regulator had acted in 2015 or 2016 or 17, I think that we will not be having this level of conversation. So MTN, I mean, as a player, MTN still believes in the market. But I think for now, whilst we are talking about MTN, we also need to be talking about other players that are also not doing well, other players that are also not investing. So if we resolve the issue of MTN and the other players do not invest in the market, and MTN escalates their investment, in 2 or 3 years, we will still come back to this situation. So I think, as I said at the beginning when this whole issue started, I think that the regulator needs to ensure the licensing requirement comes with some level of investment so that this issue of some of them slowing down and others running fast and later telling those who have reached the final threshold to pause, so that those who are asleep market, because the market is there to reward hard work, not inefficient players.
All right, thank you very much. Apia Kwesi Adomako is with CATS International. We appreciate your insights this evening.